This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawar Namatanda.
I'm BJ Lamsal.
And I'm Jennifer Raphael. In this special episode ahead of SoCLA's 2026 conference in Sydney, we hear from 4 legal thinkers who presented at our most recent conference in Brisbane. First, Special Counsel Cara North and Associate Eleanor Clifford, both at Corrs Chambers Westgarth when we recorded this interview, discuss how the High Court's Tesseract decision changes risk allocation. Then, Sean Brady, who is Managing Director at Brady Hayward, reflects on the Space Shuttle Challenger disaster. He outlines how the disaster highlights lessons for modern organisations about risk, safety systems, and speaking up. Finally, we hear from Wayne Jocic from Melbourne Law School. He explores how a principal's unilateral power to extend time may affect contractors' delay claims and reflects on the relationship between academia and practice in construction law. So let's jump in, starting with my chat with Cara North and Eleanor Clifford. Cara and Eleanor, welcome to the show.
Thank you.
Yeah, thank you.
It's great to have you here. We've just heard your fabulous presentation and your equally fabulous paper. How does it feel to have your work recognised this way?
Yeah, I think it's funny because this has been a topic we've been thinking about for a number of years, and we were really glad to be able to submit the paper and have it be in a final form, and then we got it published recently in the International Construction Law Review, and now getting to present. It feels like the end of an era a little bit, but it's been really great.
Well, the paper is highly relevant. Eleanor, for those who missed the presentation or maybe haven't read the paper, could you briefly explain what it's about?
So our paper is about multi-party and multi-contract arbitration in the construction sector. So essentially, if you're dealing with a construction law dispute that's being heard by a court, often there are lots of parties who are involved in the relevant project and lots of parties who are subject to different claims and making different claims that are all kind of related to the same project that's being built. And in a court proceedings, it's fairly common and easy for a judge to order that related parties be joined to the proceedings or two related proceedings be heard and determined together, and that just allows them to be resolved efficiently. While that's not the case in arbitration, because arbitration is a consensual mechanism, it's actually very difficult to bring in related parties or hear related disputes at the same time. So our paper was sort of talking about this issue and the potential solutions that may be found in the Australian arbitral regime under the AKICA rules. Also, we talk about linked claims regimes and standard form contracts, and then we give some advice for how to resolve these issues at a front-end level. So it seems like we packed a lot in our paper.
You certainly did. You definitely packed it all in. Cara, what sparked your interest in this particular topic of multi-party arbitrations?
The idea for the paper actually came from some advice that we had been given to a client in the context of our work. And we worked through quite complicated different scenarios that had arisen out of a complex multi-party, multi-contract construction dispute. And we worked through all of those different scenarios and what the client could potentially do when there were different arbitration clauses at play in the various contracts and how the parties could be joined together into a single proceeding. And after we worked on that paper, we thought this is an interesting topic that's highly relevant in construction and would be good to document what the possible solutions are and try to get front-end lawyers to think prior to a dispute arising about how they can assist their back-end lawyer colleagues to make the process of bringing everybody together simplified.
Yes, make their life a little bit easier.
Exactly.
So, Eleanor, the paper discusses the High Court's decision in Tesseract as a game changer. What is so significant about the case for construction arbitration?
So essentially, prior to the decision in Tesseract, the widely held view was that proportionate liability legislation, where the arbitration, the substantive law was that of Australia, proportionate liability legislation didn't apply to the arbitration. And that was because of the very issue we talk about in the paper, which is that it's incredibly hard to bring in related parties and alleged concurrent wrongdoers into an arbitral proceeding. However, in 2024, the High Court's decision in Tesseract reversed that position and held that in certain circumstances that proportionate liability legislation forms the substantive law of Australia and will apply to arbitrations even if the alleged concurrent wrongdoers cannot be joined. And so this really changed the way that a lot of contracting parties are thinking about multi-party and multi-contract disputes, because before you could bring one claim in arbitration against one defendant and have all of your issues resolved there. But now if the defendant successfully argues that there are concurrent wrongdoers, then the party bringing the claim will have to go out and recover the rest of their loss from those other parties. So rather than arbitration being essentially a one-stop shop to resolve the dispute, it may lead to multiple separate proceedings needing to be commenced.
Yeah, absolutely, which can really impact upon it being cost effective, can't it? Are you both seeing any of the effects of this decision in practice with your own clients?
We have seen the effect of it in the context of one case, but I also have seen it now coming up a lot of the time in contract drafting. So when we get sent a dispute resolution clause from one of the front-end construction lawyers and seeking advice from us on how to cater for multi-party, multi-contract disputes and what, depending on the party that we're acting for, what should be said in the contract with respect to proportionate liability legislation, how it's going to apply, are they able to contract out of it, is it advisable to do so, and so on. So we're seeing it from a front-end perspective, but we're also seeing it from a back-end perspective as well once a dispute has arisen, particularly in relation to disputes that are occurring in Queensland where you can't contract out of the proportionate liability regime.
And do you think it will have an impact or make arbitrations less likely, or the parties less likely to turn to arbitrations in the future?
Yeah, this is something we've kind of spoken about. I think there are so many benefits to arbitration that make it so attractive, particularly for construction clients, either because it's confidential or you've got more control over the procedure or you get a say in who's on the tribunal, particularly where these disputes can be incredibly technical. You want an adjudicator to have some relevant background experience. But I think it depends. I think it's unlikely to lead to a full shift away from arbitration, particularly because it's the preferred method of dispute resolution in so many existing contracts, but it may be something to think about.
Yeah, and also I think the decision of Tesseract, putting that to one side, this issue of multi-party, multi-contract arbitrations, when we were doing this advice work initially, I mean, this is not new. This has been a feature of construction arbitrations forever and a day. And despite the difficulty of bringing everybody into the one proceeding without a lot of forethought about how you're going to do that it's still the preferred method of dispute resolution for the construction sector. So, yeah, I'd be shocked if it results in a complete move away from arbitration.
One thing I really like about your paper is that, as well as highlighting the problem, you also look to what the practical solutions, or what some of the practical solutions are in respect of multi-party arbitrations. And some of the solutions that you canvass in your paper range from the AKICA rules to joint arbitration agreements. Do you have a sense on what would be the most practical solution?
The best solution would be for all the parties to sign like a joint arbitration agreement, or have the parties all consent to be party to a consolidated or joined to an arbitration in their respective contracts. I don't know if that's the most practical solution from the perspective of what parties will agree to. If this is a key issue and you can foresee it being an issue for your client, that's the best case scenario in our advice.
Yeah, I think some of those difficulties with getting that agreement were discussed in the presentation, because it's where those interests aren't aligned.
Yeah.
It can be difficult to reach consensus.
Or even it really being thought about from a front-end lawyer perspective. I think front-end lawyers are often not thinking too deeply about the structure of the dispute resolution clause or what a dispute will look like. So I think the purpose of our paper and the presentation is just to put this on specifically front-end lawyers' radars to be thinking about and advising their clients on, because when you get to the time of a dispute, from our experience, it's very difficult to resolve these type of issues.
Absolutely. And so turning now to, from the front end perspective, Cara, what practical advice would you give to parties with respect to drafting these types of clauses?
Yeah, so we stepped through in our paper a couple of the different options and in order of priority. As Eleanor mentioned, I think the first or best solution would be for all parties to be a party to the same arbitration agreement, because that way then all the dispute can be heard and determined in a single forum. And then the next best option would be for the parties to adopt the same arbitration clause in all related contracts, which requires the dispute to be resolved under arbitral rules that provide for multi-party solutions like joinder or consolidation or commencing separate proceedings against multiple parties. So that would be, the next best option.
And then looking ahead, Eleanor, do you think we'll see changes to standard form contracts or industry practices to respond to these particular challenges?
I think it's tricky with standard form contracts because, I don't know too much about construction standard form contracts. So it may make changes to in-house standard form contracts. I think the published versions, there's clearly not a real emphasis on the dispute resolution clause beyond just referring to arbitration. But for construction lawyers in firms and in construction companies, I think the Tesseract decision in particular may be the impetus to start considering these type of issues within their standard form contracts. And then in terms of the industry, I'm not sure. It's also hard. Something we've not mentioned is that arbitration is confidential. And so it's actually very difficult to know the impact beyond what you're dealing with your clients, which is also confidential. But if there is a full-scale change, it'll take a long time to see that because it takes a while we may never know because of the confidentiality around arbitrations until practitioners start being able to talk about it.
Well, thanks so much for joining us on the show.
Great,
thank you for having us.
Fun.
That was Cara North and Eleanor Clifford. Now to the Challenger space shuttle disaster and what it can teach us about risk, safety systems, and speaking up. In this conversation, I'll be speaking with Sean Brady, Managing Director at Brady Hayward. Sean, welcome to the show.
Good to be here, Jen.
Sean, yesterday you presented on the Challenger disaster. For those of us who weren't there or, like myself, weren't even born at that point in time.
Don't say things like that.
And may not know the full story, can you take us back to January 28, 1986? What happened that day?
So this was the launch of the Challenger mission, or the Challenger shuttle, which the mission was actually called STS-51L. And this mission was a little bit special because on board was Krista McAuliffe, who is a school teacher. She was going to space as part of a sort of a recognition of the importance of teachers in the US. So it was a very, very high profile mission. It was a very cold day. When they launched, 73 seconds after the launch, everything seemed to be going fine. But at 73 seconds, there was a failure. And they basically lost the shuttle and lost the crew. So it was the first set of really bad fatalities in the space shuttle program. Not the last either.
No, definitely not. And so during your presentation, you took us through the issue that occurred with the O-rings and what happened there. It wasn't just a technical failure, but it was also a failure in risk management and organisational systems. What does that mean?
Yeah, so I like to say that, we have these engineering failures, which obviously have technical causes, but for every technical cause, you always get a set of organisational causes that allow that technical issue to progress to the point where you can have a failure. And the technical issue here is that there was a set of O-rings on one of the solid rocket boosters, which is those two little mini rockets you sort of see on the side of the fuel tank on the shuttle. They caused hot gases from the boosters to leak out, actually strike the fuel tank, and that's what led to the loss of the shuttle. The interesting thing was that the potential for a leak had been known for a long time, basically back to the second mission of the space shuttle back in 1981, so 5 years earlier. And what was happening here is what has been identified as normalization of deviance. And what is normalization of deviance? Well, it's fundamentally where you start off with a technical issue, these O-rings were not behaving the way they should have been to prevent hot gases escaping from the solid rocket boosters. And you end up in a situation where you're concerned about that. You do some analysis about that, but you normalize this deviation. We shouldn't have these issues over time. And one of the reasons you normalize these things is because every time that shuttle went up and every time that shuttle came back, that was taken as proof that, yeah, we've got some issues, but the shuttle's fine. And the more times that happens, we normalize the deviance that initially concerns us. And normalization of deviance has been identified in many failures, and it's a real thing, and you have to, as an organization, put proactive things in place to catch it, identify it, and do something with it.
Absolutely. And it's amazing to think of an organisation like NASA with some of the world's brightest engineers falling into this trap. So what was it particularly about NASA that you think allowed this to occur?
Yeah, multiple things. So really interestingly, if you go back to the Apollo program to go to the moon in the 60s and 70s, that was always seen as a high-risk task. It was always an experimental task where you never were quite in operational mode or what could go wrong. But one of the really interesting changes that occurred when they went to the shuttle program was that the sort of enthusiasm of the American public wasn't there to fund this shuttle. So the shuttle had to be able to pay for itself. So the shuttle had to be able to launch regularly. They initially wanted to launch it every fortnight, and they wanted to get it from a research and development project to an operational project really quickly so that everyone could say, look, this is worth the money. This is not just about going to the moon or something like that. This is actually a practical thing that's benefiting the US. That shift was critical because really what they did was they moved from that R&D status to the operational status without fully understanding the vehicle. Like, this vehicle is one of the most complex things human beings have ever designed and built. And that puts you behind the eight ball all the time, because if the vehicle is operational, why are you worried about it? You should just be doing maintenance with it. Everything should be fine. So that sort of pressure leads to an environment where this normalization of deviance can happen and is even potentially rewarded, because if you're making a fuss about things that haven't happened yet and you're able to keep the shuttle program moving, then that tends to make people in that program happy, and we keep doing what we're doing.
And from your work on the Brady review into mining fatalities in Queensland, do you see these same patterns playing out in other high-risk industries today?
Oh, yeah, absolutely. So interestingly, we did the review into mining that was looking at 47 fatalities between the year 2000 and 2019. And the overarching finding that I would say came out of that was that people get killed when the controls that are meant to control the hazards, are ineffective. Now, that's really interesting for a number of reasons. One, in most cases, we've identified there is a hazard. In most places, we've written down as an organisation somewhere that a control needs to be in place. And then that control doesn't work on the day. So we a little bit cheekily say, to try and get people's attention in the mining industry, that it's not hazards that kill people, it's ineffective controls. So what organisations really, really need to do is understand, what are my controls? Are they effective? And how do I know they're effective? How do I stay on top of that as an organisation? And that's a bit of a shift. We talk a lot, and particularly in construction law, about risk. Oh, we need to manage risk and identify risk and all these sorts of things. We typically, as human beings, spend a lot more time looking at what's the hazard, what's the risk, and not focusing on, I've put a control in, but is it any good? Does it actually?
Definitely. Spending that time actually critically thinking about these things seems to be vitally important.
Yeah, it's interesting. Most organizations go about the business of managing hazards by designing a system to keep their people safe and then making sure people follow the system, making sure people comply with the system. With the implicit assumption being that if they do so, they won't get hurt. Now, we know that doesn't work because it's impossible to design a perfect system. What you actually need to do is try and design a perfect system and then seek constant feedback on where that system isn't as effective as you think it is. Turns out organizations are pretty bad at that, because that effect, getting the feedback that your system isn't effective is perceived as bad news. It's believed as scary news, particularly involving safety. After all, if the safety system is effective as we think it is, that's genuinely terrifying. But That's the step change between organizations that are truly safe, what we call high reliability organizations, versus what the rest of us do. The rest of us believe you can keep people safe by making them comply with a system. High reliability organizations know you can't. They know that what you need is constant feedback on where your system isn't effective. And they do a huge amount of work at building in the practices in their organization to give them that information.
And it seems like what's needed is the acknowledgement that nothing's infallible, and that really you need to acknowledge that there are going to be failings, which we as human beings don't really like to do.
Yes, and it's interesting. I heard one person say recently, we're not trying to prevent all accidents, we're trying to prevent all harm in accidents. So that if something happens, there is human error, there is bad luck, that the system actually kicks in and protects the people. That's what we're actually trying to do, because we know we can't get rid of the human error, and we know we can't get rid of bad luck because that's just the way life is. But what we can do is make sure that people are protected by the controls if they fail. And if you go back to Challenger, it's really no different. You know, they had these layers of controls. They had a primary O-ring to stop gases escaping. They had a secondary O-ring to stop gases escaping. And the normalization was to progressively allow more and more damage to occur to those controls that were meant to keep people safe.
So what do you think is the most important lesson from Challenger then that organisations today need to take on board, particularly maybe in respect of professional services organisations or even our own legal organisation industry?
I think it's all about knowing that, you know, regardless of what profession we're in, we're trying to stop bad things happen. If it's the law, you're trying to stop bad legal outcomes, whatever. And it's all about basically saying, you know, I believe I have an approach, a system to do that. Now am I willing to listen to feedback where it's probably not working? And we don't want to do that. That's the hard thing to do. And the organizations that are good at it are really good at saying, no, actually, we do want to know. And they accept that that's flows against human nature, that it's actually really difficult to get people to speak up about bad news and where the system isn't working. That's the hard bit. And it's hard as a leader to accept you can't design a perfect system.
And I suppose it's making it safe for people to speak up about these near misses or the failings so that we can have those lessons learned instead of keeping it hidden.
Yes, and I would say it's interesting. So it's all about putting in practices, doing things that actually encourage people to speak up, educate them about the things they should be speaking up on, rewarding them for speaking up. They're the sort of practices you have to put in to actually get it. Because what we see a lot of is a lot of leaders saying, yeah, we want people to speak up. And then they wonder why they're getting no reports of issues. But when you dig into it, you find people get disciplined. You find that they have raised issues before, but they don't get escalated by certain management levels because that's their patch and they don't want their patch to look bad. So it's this really conscious, concerted effort that you're after to try and turn around how the culture thinks and works.
Absolutely. So the presentation yesterday was really powerful and quite emotional. The image of Challenger floating back down to the ocean was particularly emotional. Can you share what makes the story of Challenger so personally impactful for you?
I think it's what makes Challenger really interesting is that you're in a really difficult technical environment, highly complex. There's a lot that, you know, NASA was trying to manage. Yet they got quite clear warning signs that they had a problem. And because the normalization of deviance, we know that that problem wasn't dealt with in a good way. But then you get up to the night before the launch where the engineers actually try and stop the launch, but because they haven't the data they need to be able to convince NASA not to do the launch, then the launch goes ahead. I think that's just an incredible story of people trying to do the right thing, but because of the way everything's gone to that point, they're not able to have an impact. And I think we didn't get into it in the presentation yesterday, but they went and they fixed the O-rings in the solid rocket booster. They fixed the technical problem. Fast forward 7 years, we have the Columbia disaster. Columbia disaster happens because insulation falls off that external tank during liftoff, strikes the heat shield of the shuttle. When the shuttle's re-entering days later, heat penetrates the heat shield, basically tears apart the shuttle, and we lose another crew. And the findings in that investigation were fascinating because technical cause was totally different. Organizational cause was largely the same. They identified normalization of deviance as well because pieces of foam had been hitting the heat shield from the very first launch. And rather than it being viewed as, oh wow, we could damage the heat shield, because it happened on pretty much every flight, but every flight came back, the normalization of deviance kicks in, people decide this was a concern, it's not anymore. It even gets downgraded from a flight safety risk to a maintenance issue.
And during your presentation, I think a lot of the audience could feel the frustrations of the engineers in the Challenger disaster with trying to get the powers that be to come on board and to stop the flight. It particularly resonated with me when you were talking about the fact that they sent through the fax trying to get Alan McDonald signing off on the facts to say that it was all okay. I think a lot of us lawyers in the room could understand why he didn't want to sign that one. There was a particularly powerful quote that you ended with yesterday. Would you mind sharing that with us again?
Yeah, so this was a quote that was said by President Reagan later on that day. So this was at a point where people were really trying to figure out what was happening, trying to cope with it. I mean, it had been incredibly traumatic for the whole nation because they watched it all on live TV. And he said, the crew of the Space Shuttle Challenger have honoured us with the manner in which they lived their lives. We will never forget them, nor the last time we saw them this morning as they prepared for their journey and waved goodbye and slipped the surly bounds of earth to touch the face of God.
Very powerful.
Yeah, sure is.
Well, thanks so much for joining us on the show, Sean.
No problem at all, Jen. Thank you.
That was Sean Brady, Managing Director at Brady Hayward. Next, I'm speaking to Wayne Jocic, Associate Professor and Co-Director of Studies at Melbourne Law School at the University of Melbourne. In this discussion, Wayne examines how a principal's unilateral power to extend time can influence contractors' delay claims. He also offers insights into the relationship between academic research and the practice of construction law. Wayne, welcome to the show.
Thanks very much, Jen. Lovely to be here.
That's great. So we've just come from the Push Me, Pull You panel, which I confess I did not know what a Push Me, Pull You was before the session. So I've learnt something new today. And I was really interested in your presentation that you gave and the legal problem that you spoke about. Would you share with our audience members what your presentation was about today?
Sure. It's kind of you to say that it was interesting. I think it's interesting in a significant degree to about 5 people, but I do think it's a kind of important issue. So the basic idea is that in lots of construction contracts, we have delays for which a contractor will get extra time and some where they get extra time and extra money. And on top of that, construction contracts often give the principal the power to extend time unilaterally. So really, my speech was about what happens when you put those two ideas together and you have a nefarious principle.
Yes, that's right. So you raised an issue which I hadn't thought about earlier, which is a principal utilising that unilateral power in order to prevent the contractor from being able to get delay damages for a compensable claim. So that was really interesting, something I hadn't thought about before, and I think it goes to highlight what the panel was about, which is talking about the intersection between the academia and lawyers and the commercial problems that we have to deal with on a day-to-day basis. Is that something that you regularly present on, regularly have to think about?
So I think you're right to draw that link to the theme of this little session, because this is an idea that I would never have thought of. It just seems too dastardly. It's very hard to imagine a principal or lower down a contractor being so despicable. But this is something that was raised with me in teaching, and a group of commercial people from one of the big builders asked my opinion on it, and I just stopped because I had never thought of it. And once I did start to think about it, it became quite interesting legally. And of course, when you have these difficult questions, often there's a simple solution in drafting.
Absolutely. And so you were one of a number of members on the panel talking about this kind of intersection. Was there a particular discovery or insight from one of your fellow panellists that you thought was particularly interesting?
Sure. I'm going to pick on what Jessica discussed. So she was essentially talking about the current status of good faith in Australia, comparing it with some other jurisdictions, looking ahead, trying to deal with the difficult problem of the High Court refusing to deal with this issue. So that was particularly interesting to me because it had some parallels with what I was discussing, and also because it's an important area in contract law, which is an area that I teach and research in.
Absolutely, yeah. I found her presentation really interesting as well. And I think it also reminded me of a comment that Julie spoke about, which is about large law firms not really being willing to be innovative or struggling to be innovative. And I think she made that comment as well about this issue of, is there a duty of good faith, and about the fact that lawyers aren't willing to put the argument before the courts, but the courts also want lawyers to put it before the court so that they can discuss it. So that was really interesting, I found.
Yeah. I mean, let's think about this. Why would you turn to a lawyer for innovation? So first, think about the training. Everything we do is indoctrination by precedent. So it's an inherently conservative discipline. We look to what has been decided in the past, and then a little apprehensively we think about whether we might be able to extend that just a little, but not too much. So that's one feature. Our training just makes us conservative in our discipline.
Absolutely.
And then on top of that, you have all of the considerations of professional indemnity insurance and your reputation and those sorts of things. So that's understandable. But what it does mean is things can stultify in the law because there are so many inhibitions to doing new things.
Absolutely. And you yourself have worked in private practice and are now in the academia. How do those different worlds, I guess, inform each other in your approach to construction law?
Look, I would be a terrible academic if I hadn't practiced. So I worked for about 10 years as a front-end construction lawyer in one of the big practices. I was a consultant part-time at another firm for about another 10 years. And so I hope I made some contribution in those roles, but certainly they've really enriched my academic life. As a researcher, of course, because you encounter all sorts of weird things in practice and they prompt ideas, but particularly in teaching. So I teach people contracts and remedies in the JD program, and I teach all sorts of things in the construction law master's program. And I have a bit of confidence saying this is just not going to work if you see particular drafting. And it just means you're sort of comfortable dealing with contracts and you know who's doing things in the industry. And so I think that those links are terribly important. And let's be honest, far too few academics have extensive practical experience.
And what challenges do you face when translating academic research into practical solutions?
So one of the things I think is that wariness of innovation that many practitioners naturally have. There's another pressing problem too, and that's that in theory, at least as an academic, you have a bit of time to sit back and think about things. And that's difficult to do in practice. It's difficult because there are immediate and totally unreasonable deadlines and everything is due within a few hours. And then there's also the pressure of budgets. And you can't go off for one client and do all sorts of development work and expect them to pay for that. So there are some difficulties in that sort of translation. But what I would say is most lawyers recognise that an important part of their professional obligations is to think about the law, to learn about the law. And so, sure, there's some obstacles, but I think overwhelmingly people do want to learn from one another, both at universities and in practice and in so many forms.
Yeah, and I think what you just said there was really highlighted by the problem that you presented today, that exact point about lawyers on the ground not having the time, the resources, the ability to really sit down and think about these kind of issues. Now, do you find that students coming through your construction law program have different perspectives about the industry to those who might be more senior?
So one enormous luxury is that plenty of the people that I've taught over the years have become more senior, and I think that's helped to change the way parts of the industry do feel about academic work and do feel about developments in construction. But one thing I will just comment on as a bit of a tangent is that it's a great enjoyment to me to sit in a classroom where you have people who represent contractors, principals, people who work for consultants, for minor subcontractors, and they work around the world on very different projects, from gigantic oil and gas projects to domestic work. And so those differences of ideas and sometimes that sort of tension in the discussion is great, because we all learn from one another, because even if we've been in the industry for 40 years, we still only have a limited set of experience. And so that diversity of opinion is fantastic.
Absolutely. Yeah, it's so needed. Are there any particular areas that you think academic research is currently needed in construction law?
I might actually broaden that and go beyond construction law and say that there's a difficulty in Australia in private law generally. So very few people go on to do PhDs in private law, things like contract, property, those sorts of things. And so lots of teaching is done by sessional staff who might be fantastic or might be relatively new to the job. And it's difficult to retain really good private lawyers, really good construction lawyers, because often they look at some job in practice and think, well, that's a job that'll pay me several times more than I'm getting at a university. So I think that's a problem in Australia and also around the world. It's difficult to source a very experienced, very capable private law scholars. Not just construction, but construction's a special problem because in many respects it's a new academic discipline.
And construction lawyers are so busy.
They certainly are.
Now, we heard earlier in the conference from Adam Pearl talking about the standardisation project, and later today there'll be a roundtable discussion about that. Looking ahead to that roundtable, why do you think the topic is important enough to warrant this discussion?
I think the topic is important enough to warrant this discussion because the way most of us contract is how we might have contracted in, say, 1970. And the contracts are a little bit longer, but we still have the mindset that we have essentially a typewritten set of terms, and then we add some special conditions. There's a great advance of word processors, and we have lots of red and blue and green tracking of changes, but we still have that same mentality that we start with a standard form contract, which often is outdated, which doesn't deal with modern legislation, which doesn't deal with modern construction practices, and which has a risk allocation which is perpetually amended. So in a sense, what we have is so obviously backward that it's astonishing that we haven't been able to improve over the course of decades. To give you one example, very often people will be dealing with contracts, say from Sands Australia. They might be dealing with the AS contract, a simple construct-only contract, and it's a contract from 1997. And so if you think about the legislation in that time, it doesn't have a GST clause. The GST didn't exist at that point. And then, of course, there's all the environmental legislation and so on, none of which is mentioned. That's not even to trouble ourselves with all of the court decisions considering some of those clauses and changes in construction practices and so on. So it just seems to me that the system that we currently live with is patently out of date.
Absolutely. I was nodding all throughout that for the listeners at home. And what do you think the main barriers are to that standardisation?
That's a very good question. It's one that we're going to explore this afternoon. But I'll step back to some research that my colleagues and I did at Melbourne Law School in 2014. What we found was that the dominant reason that people chose a particular standard form contract, not because it suited the particular project, but because they were familiar with it. So they already had standard notices and so on. They knew the clause numbers off the top of their head, and people just did not want to shift. So people cling to older forms. We take an international example of the FIDIC contracts, which some people might have encountered. People now regularly use the 1999 versions of the contract, and the brand new 2017 contracts in many ways don't seem to be used. They're languishing. People cling to what they know. So that seems to me to be one compelling reason. People use what they know.
Absolutely. Now, is there anything that you'd like me to ask that I haven't already asked?
No, there's not. But what I might just do is put in a bit of a plug for this conference and just say how wonderful it's been to have seen so many speakers from around Australia, to have had so many delegates here from overseas, to have heard from lawyers and non-lawyers about, quite technical legal matters in some cases. In others, for example, in the panel today, discussion about the role of queer people in the construction industry and what we can do to support them. The diversity in the conference has just been extraordinary. And it's the sort of conference that you can come along to and a few months later still be thinking about some of these ideas. So it's been a lot of fun for me, and I'm sure for all the other people here.
Absolutely. I still refer back to some of the papers from last year's conferences, so it is really valuable. Thanks so much for joining us on the show, Wayne.
It's lovely to be here. Thank you very much.
Thank you. That was Wayne Jocic from Melbourne Law School, rounding out our special 3-interview episode of speakers from the most recent SoCLA conference. To hear more great thinkers in construction law, join us at the 2026 SoCLA National Conference, which will be held in Sydney from the 6th to the 8th of May. Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career, with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au. This show was produced with strategy and production support from Sound Cartel.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawuna Matanda.
I'm Bijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.